we believe that will assist. I'm not necessarily going to refer to that bundle or those bundles in any detail except for one or two, but that is what that is. And just one further point. The document was originally prepared, Judge and members, with reference to the statement of case. And given that the statement of case footnotes and the submission footnotes given that the statement of case footnotes and the submission footnotes are different, we've given you, and they are loose pages. The second one is the first one, it's loose because that's been ring bound. The second one is, so that index you'll find is loose, Judge, and I believe that's the updated index. So that would be the updated index for that document. You can ignore the index that's attached if there is still one attached. The second bundle is in a Lebarge file, and thus the original index has simply been removed, and what you have is the correct index. So that's by way of preface. If we can then proceed, Judge and members of the board, to our written submissions. It's common cause. We all are in agreement as to what the purpose of this board is. And if I could just refer you to, and I apologize, it came to my attention when I was preparing that pages 6 and 7 have been inverted in our heads, so 7 precedes 6. If you could just make a note of that and when you read it. If I could then go to page 5, and to begin, this is an inquiry in terms of section 9.1, we know of the Act. And that provides that subject to this section, subsections 1 to 8 of section 8 of the Act applies mutatis mutandis to any inquiry into allegations of misconduct by the National or Provincial Commissioner or into his or her fitness for office or capacity for executing his or her official duties efficiently. And that is now, you then have to skip page 7 and go to the next page, which is page 6. The Board of Inquiry established by virtue of subsection 1 shall make a finding, and this speaks to your powers and duties at the end of these proceedings, shall make a finding in respect of the alleged misconduct or alleged unfitness for office or incapacity of executing official duties efficiently, as the case may be, and make recommendations as contemplated in section 8.6b. Now, the recommendations as contemplated in 8.6b are dealt with members on page 7, and we know from subpara 8.6a in the middle of that page, at page 7, at the conclusion of the inquiry, this board shall submit its report to the President, in the present case, and then in B at the bottom, the report referred to in paragraph A may recommend, and a series of possible recommendations are then dealt with, and that you find on page 8. And they include Roman 5, that he or she be removed from office. And then finally, with regard to the Act's provisions, the President in sub 7, the President may, upon receipt of a recommendation contemplated in subsection 6, remove the Commissioner concerned from office or take any other appropriate action. So what is clear, we submit, is that at the end of these proceedings, you will evaluate the evidence with regard to the terms of reference, and you will make a recommendation. And the President is at liberty to accept that recommendation or not, as he sees fit. And that is what the structure of this process is. Now, in paragraph 4, we make the submission that inquiry in terms of section 9 of the Act is akin, and we use that word advisedly, akin to a disciplinary inquiry and is structured as such. The terms of reference set up the scope of the inquiry. It is clear that the present inquiry is not a general inquiry into the fitness of the National Commissioner, but is confined to the conduct of the National Commissioner in relation to the events at Marikana and evidence in relation thereto the following Commission. And the inquiry into General PF's fitness for office arises from the adverse findings made by the following Commission. We then go on in the next section to deal with the principles against which to measure the conduct of the National Commission on Fitness for Office. And we begin with reference to the Constitution and national security. And in this regard, members, we refer to Section 198 of the Constitution, and you'll be aware that the Constitution is, security services are dealt with in Chapter 11 of the Constitution. And the governing principles are what you find in Section 198. And the first of those governing principles, which govern national security, is that national security must reflect the resolve of South Africans as individuals and as a nation to live as equals, to live in peace and harmony, to be free from fear and want and to seek a better life. Sub B is not directly relevant. C says national security must be pursued, and this is highly relevant, in compliance with the law, including international law, and then national security is subject to the authority of Parliament and the National Executive. And that's sub D, and that's been touched on to some extent in the engagement with Mr. Mpofu this morning, and doubtless that will be returned to during the course of these submissions. Then Section 199 of the Constitution, and we've quoted it on page 10, are particularly relevant because the security services, subsection 1 provides that the security services of the Republic consist of a single defence force, a single police service, and any intelligence services established in terms of the Constitution. And then, highly relevant for present purposes is what you find in sub 5. The security services must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. In para 7, we quote the Constitutional Court judgment in Masetla v. President of the Republic of South Africa, and we submit that the Constitutional Court reinforces our understanding that national security is a relevant consideration in this inquiry. Now, you'll be aware that issue is taken with that proposition in the statement of response. And I'll refer you to the passage where the suggestion is that this case has nothing to do with national security. And we submit that is a very misguided and myopic view of the responsibility of the National Commission and her obligations under the Constitution. But to refer to Masetla, Judge and members, in paragraph 33, we refer to it on page 11 of our submissions, where the Constitutional Court said that the security services of the Republic consist of a single defence force, a single police service, and any intelligence services established in terms of the Constitution and must be structured and regulated by national legislation. Then the Court says, predictably, one of the important principles prescribed is that national security must be pursued in compliance with the law, and security services must act and teach and require their members to act in accordance with the Constitution and the law. Now, this is the relevance of this statement and our approach to the matter. Besides the rule of law imperative, this constitutional injunction is also inspired by and deeply rooted in the repudiation of our past, in which security services were for the most part a law unto themselves. They terrorized opponents of the government of the day with impunity and often in flagrant disregard of law. Now, the relevance of that, of course, Judge, is, without being dramatic and melodramatic, is all of us who lived through apartheid could not but be reminded of the pain and the anguish of those days when citizens were faced by armed police. When we saw the images of Marikana, it's etched in all our collective memories. And it is that aspect and the repercussions, both economic, political, social, and personal, as evidenced by the people who are here, that demonstrate why this is a national security issue. For something that happened in a democratic South Africa to go so badly wrong that 34 people are shot dead in a single day by the custodians of the law, who are supposed to act in terms of the provisions I've just read to you and other provisions that I'm going to read to you, is not acceptable. And that is what implicates national security. Now, one would have thought that is self-obvious, but the response of the National Commissioner, you find, members, at paragraph 76 of their statement of response. And in that paragraph, in response to our paragraph 24 of our statement of case, and our paragraph 24, the paragraphs are now different, is a repeat of what we say in paragraph 8 of the present submissions. But in response to that paragraph, and perhaps let me read to you what paragraph 24 of the original statement of case says, and we say it immediately after quoting Masetla's case. We say the question, therefore, is whether the National Commissioner's management and control of a major policing event involving the Marikana strike demonstrated an acute sensitivity to national security considerations. It is clear that if the management and control of the Marikana events did not demonstrate an acute sensitivity to national security considerations, the National Commissioner is not a fit and proper person to manage and control the police service. Now, in response to that, members of the board, at paragraph 76 on page 29 of the statement of response, we have the answer: a reference to national security and security considerations is wholly inappropriate in the context of the terms of reference which bind this inquiry. So the response is it's inappropriate. It has nothing to do with this inquiry. And we say that speaks volumes of the perception that the National Commissioner has of a role. In paragraph 9, members of the board, of our submissions on page 12, we refer to section 205.3 of the Constitution, which provides that the objects of the police service are to prevent, combat and investigate crime, to maintain public order, to protect and secure the inhabitants of the Republic and their property, and to uphold and enforce the law. And we say that must be read together with the relevant provisions of the Police Act, including its preamble. Then in paragraph 10, we refer to section 207 of the Constitution, and 207.1 provides that the President, as head of the National Executive, must appoint a woman or man as the National Commissioner of the Police Service to control and manage the police service. Then section 207.2 says, of the Constitution, provides that the National Commissioner must exercise control, and this is an extremely important provision in the context of this case, or this matter rather, again because of the attitude adopted by the National Commissioner, in which which is referred to in our submissions and in her the submissions on her behalf. Section 207.2 of the Constitution provides that the National Commissioner must exercise control over and manage the police service in accordance with the national policing policy and the directions of the Cabinet member responsible for policing. Now, you referred to that provision earlier today, Judge, and in section, and there is a provision which I'll find in a moment, which provides that no member may be, it's under 199. So those directions that we see in 207, Judge, that the National Commissioner exercises control of the police, but in accordance with the national policing policy and the directions of the Cabinet member responsible for policing, it's self-evident, we submit that, and there was some debate this morning as to what constitutes directions. No doubt, we have no submissions in that regard, but you'll hear submissions no doubt. But the one point we'd like to make at the outset is that whatever those directions may be, they are subject to section 1996 of the Constitution, namely that no member of any security service may obey a manifestly illegal order. So what that means is that if there was an instruction, we're not saying that there was, that was clearly unlawful, illegal, there's no obligation on the National Commissioner to obey such an instruction wherever it came from. It could have come from the President. The obligation, in fact, is directly to the contrary under the Constitution. She should resist any such attempt to influence her or to give an unlawful order. On page 13 of our submissions, we refer to the relevant provisions of the SABC Act. In para 12, we say that Section 11.1 of the Act provides that the National Commissioner shall exercise control over and manage the police service in accordance with Section 207.2 of the Constitution. So it directly incorporates those provisions. Section 11.2 we then refer to. Paragraph 14, we refer to the specific powers in terms of Section 17 to set up a national public order policing unit. And we then elaborate on that in the remaining paragraphs. We could then take you, members of the board, to paragraph 17 of our heads of argument or submissions on page 15, under the heading Basic Values. Sorry, Judge.
Just before you carry on.
Certainly.
You are aware that Section 2181K of the Interim Commission has been amended. It's amended in Annexure D of the final Constitution.
I am aware of that, Judge.
Yeah.
Sorry. I am aware of that, Judge.
Yeah.
I don't take the point, we don't elaborate further on 2181K, but I'm aware that it's been amended in terms of the Constitution. If I could then take you to paragraph 17, Judge, we make the submission that the National Commissioner as the head of the police is part of the public service, and then we refer in Chapter 10 of the Constitution, which prescribes the basic values and principles governing public administration. Within the public service, there's a public service, and that must be structured in terms of national legislation and so forth. We then, in paragraph 18, make the submission that the principles in Section 195 of the Constitution are applicable to the determination of the standard to which public servants like the National Commissioner should be held. These principles must be read together with provisions in the Public Service Act, in particular the Public Service Regulations dealing with the Code of Conduct for the Public Service. And we say the following principles are relevant: the maintenance of a high standard of professional ethics, the promotion of efficient, economic and effective use of resources, and the fostering of transparency in providing timely, accessible and accurate information. Now, Judge, with reference to those amendments in the statement of case, the response you find again in the statement of response by the National Commissioner, paragraph 82.
Paragraph 82.
82. Paragraph 82. Paragraph 82 on page 31, Judge, of the statement of response. Do you have it, Judge?
Yeah.
It's, the response to those amendments by the evidence leaders is that the contents of these paragraphs are of no relevance whatsoever to the inquiry conducted strictly in accordance with the terms of reference set out in the schedule. And we submit that is quite a startling allegation or submission to make, that she's not bound by the provisions of Section 195 of the Constitution and the concomitant provisions of the Public Service Act. But that is her understanding, it would appear.
They do the same with the Code of
They
Conduct
do. I was about to come to that, Judge. They do the same with the Code of Conduct, because we then refer in terms to the Code of Conduct, and on page 17, para 20, and could I just highlight for you the ones we specifically deal with, or that we rely upon, rather. Sorry, we set them all out. but we submit that the ones that are particularly of relevance to this inquiry are 20.2, which is Code of Conduct 1.5, which requires a public servant to cooperate with public institutions established under legislation and the Constitution in promoting the public interest. And that, we submit, is relevant because of what we say are the interactions with the Following Commission, which did not, despite the National Commission's undertaking in public to do so, evince cooperation, full cooperation with the Following Commission. Then we say in 20.3 that Code of Conduct 2.1 is relevant, which requires a public servant to promote the unity and well-being of the South African nation when performing his or her official duties. 20.5, we refer to 2.8, which requires that a public servant does not abuse her or his position in the public service to promote or prejudice any political party or interest group. The relevance of that is obvious to the submissions we've made about political factors being taken into account, and we will attempt to persuade you that those are properly within the province of this Board of Inquiry. And then 20.6, C28, requires that a public servant respects and protects every person's dignity and constitutional rights. And we submit that what happened at Marikana clearly is a serious breach of that.
I suppose you say that's a reference to the right to life.
Yes, well, the right to life is foundational, but to be treated in a manner that's consonant with the law and the Constitution, but by those who are expected to keep order. And then in response, as you pointed out, in response to that, the answer at para 83 of the statement of response is that the reliance on the provisions of the Public Service Regulations, the Public Service Act, and the Code of Conduct for public servants is completely out of place and finds no relevance in the context of the terms of reference which are binding on this inquiry. Now, those averments are made boldly. Doubtless, Judge, had the National Commissioner elected to testify before you, she could have explained her position, and I would doubtlessly have asked the questions about it. She elected not to testify before this Board of Inquiry, and I'm going to make submissions in a moment to you about the likely reason why she did that and what inferences are to be drawn from that election. But all I'm saying at the moment is that you don't know why she says what she says on her behalf is said in paragraphs 82 and 83 because she hasn't come to explain herself. The next section of our submissions, Judge, and members of the Board, is the scope of this inquiry. We referred to the proclamation in terms of which this Board of Inquiry has been set up. In paragraph on page 19, we refer to the 5 terms of reference, which have been referred to again and again. And then in paragraph 22, we say the following. As appears from the terms of reference, there are 3 distinct, although not necessarily unrelated, inquiries that the Board is required to undertake, namely, 1, whether the National Commissioner is guilty of misconduct, 2, whether she is fit to hold office as a National Commissioner, and 3, whether she has the capacity to execute her official duties efficiently. Now that is essentially not a distillation, a repeat of section 9.1 of the Act. But then we make the point that on page 21, that although not contained in section 9.1 of the Act, the President has included in the scope of the 3rd inquiry whether the National Commissioner has the capacity also to execute her official duties according to law. And that is a gloss that you won't find in section 9.1. And we point that out. We make no separate submissions about whether she's fit to... We say that she isn't on a conspectus of all the evidence. She's neither fit to execute her official duties efficiently nor according to law, but we don't distinguish between the two. So nothing turns in it from our point of view. And then in paragraph 24, we make the following point, which no doubt will be significant, depending on the Board's view of it. We say that while the board is required to make factual findings, particularly into the allegations of misconduct levelled against the National Commissioner, the second and third of the inquiries referred to above, namely those dealing with fitness and capacity, are not in the final event, conclusions of fact, but rather value judgments arrived at by consideration of the facts found by the board, measured against the requisite constitutional and legal standards, as also the managerial and professional standards with which the National Commission is expected to comply. And all that we're saying there, members of the board, is that it can't be expected of us to prove that she's not fit, or to prove that she doesn't have capacity. That's for you to conclude on the basis of the facts put before you. And the facts are facts, not conclusions. Then we refer, and I'm not going to take too long in this section, we refer to the initial skirmishing between the parties. On the 3rd of May, when this inquiry began, you'll recall that there were 2 points that needed to be decided, namely whether the evidence leaders were entitled to call witnesses who would not testify to the following commission, and secondly, whether we were entitled to refer to matters which arose subsequent to the following commission, and more particularly whether we were entitled to refer to the representations made by the National Commissioner to the President, which are themselves referred to in the terms of reference. In paragraph 26, we say that on the first leg, the ruling was the evidence leaders would be entitled to call witnesses, but that witnesses' evidence will have to be tested at the relevant time when they are called as to their relevance to the terms of reference. And then secondly, in relation to the second aspect, and I'm not going to take you through all of it, so if you could just go to page 23 on the last paragraph. For these reasons, we are therefore of the view that in regard to the second point, the answer must be in the affirmative, that the evidence leaders would be entitled to refer in this Board of Inquiry to matters which occurred ex post facto but have a direct relationship to what occurred during the following commission. That is your ruling. Then, paragraph 28, we say that even though the parties to these proceedings have agreed that they are akin to a disciplinary hearing between employer and employee, it is clear that they do not accord in all respects to the usual features of a disciplinary inquiry. In particular, the following must be noted. Section 8.5 of the SABC Act, which is incorporated by reference in a Section 9 inquiry such as the present, provides as follows: the Board of Inquiry shall determine its own procedure. And that is repeated, we say, that provision in in paragraph 3 of the term of reference. And then pursuant to those provisions, this board adopted rules which permit explicitly third parties to participate. And the very notion of third parties participating in a disciplinary inquiry is foreign to the notion of disciplinary inquiry, which is why we say clearly, and we agree with our learned friend Mr. Mpofu in this regard, that this inquiry has aspects that go beyond a disciplinary inquiry. It has constitutional aspects, it has rule of law aspects, and ultimately it bears upon a decision by the President, ultimately, who will receive this board's report as provided for in the Act, to decide whether, on a reading of your report, he should conclude that the National Commissioner is a person who can comply with Section 207(1), a person who he would want to appoint to control and manage the police service. So it's in order to enable, the purpose of this, put another way, the purpose of this inquiry is not merely, as Advocate Mpofu said, to discipline a police constable, even a police brigadier or colonel or something, for some misconduct. It is for the President to exercise his own constitutional powers apropos Section 207(1). And it thus cannot be narrowly shoehorned into the ordinary legal landscape of a disciplinary inquiry. Then, the next section, we deal with the evidence that was tendered at this inquiry, and there's been significant, if I may say so, misunderstanding, it seems, in the media about the evidence that was tendered before this inquiry. And even though you did, I think it was on day 2, you read out in fact you did read it out. You read out the agreement which the parties concluded in respect and which is encapsulated in Exhibit C. And among the provisions that you read out was that the entire record of the following commission was admitted as evidence in this inquiry. And with the greatest respect, the media appears sometimes, let me not say the media, commentators appear to have misunderstood that very fundamental fact, because they seem to be saying, well, where's the evidence? The evidence was put before you in terms of the transcript and the exhibits of 300 days of evidence led before Judge Follen. And that is your beginning point. What then comes in terms of Exhibit C is further evidence that was tendered specifically in this inquiry to deal specifically with these terms of reference. And you then know what that agreement was. We deal with it in para 30. It was agreed that the statements of the witnesses there, referred to in para 3.3, are admitted. Again, it says, shall stand as evidence before this Board of Inquiry, therefore obviating the need to call the witnesses to testify. So there's been some suggestion in exchanges with you that maybe the status of those witness statements is different to evidence. Our position is very clear. This agreement is very clear. The evidence leaders were in a position to call each and every one of these witnesses. We did not call them because the evidence was accepted as evidence. Their statements, were accepted as evidence. So it would be the same as if we'd call them, ask them whether that was their statements, whether they agreed with it, and then there was no cross-examination. That's the same status. It's evidence in all respects.
The concession made by Advocate Sello that the affidavit of Mr. Matunja would be dealt with on the same basis as the affidavits mentioned in this Exhibit C. Does that conflict with any of the provisions of Exhibit C or not?
I don't, we submit not, Judge. It would be strange to admit evidence that you consider not relevant, and we don't read in our colleagues' heads of argument any specific submission about any of the witnesses that are referred to in paragraph 3.3 on the grounds of relevance. So they don't appear to take any relevance point about any of those witnesses. In fairness to Advocate Sello, she did expressly, as one of her caveats or qualifications, reserve the right to argue relevance about Mr. Matunjwa's affidavit. So we have no interest in that debate, but obviously they've reserved their rights. So and it's been done for reasons of expediency to get this hearing along. So clearly they should be allowed to make whatever submissions of relevance about Mr. Matunjwa. Then, in para 32, members of the board, we say that in addition to these above witnesses, who all are whose evidence is now before you, we reserved our rights in respect to Captain Ntlati, and then with regard to Ms. Mashego, there was some not skirmishing, hotter than skirmishing, but there was a debate about Ms. Mashego, and you ultimately gave a ruling, and then we called him as well. And he deposed to an affidavit that you will recall was handed up to the board and marked Exhibit E. Yeah. And I trust the board has all those exhibits in a safe place. You'll also recall there was an Exhibit B, which we handed up, and which contains all the witness statements, which were referred to in in Exhibit C.
It was a whole bundle.
It's a whole bundle.
Yeah, we have it here.
You have that. Then, in paragraph 33, we say that Captain Adrià did not attend the hearings of the board as he's based in France, having been seconded to Interpol. We tended to lead his evidence by way of video link, but ultimately it was agreed with the National Commission's legal representatives that this was not required. And his original statement and the attachments thereto are in Exhibit B, and his further statement, which it seems through error on my part was never handed up formally to you, but which was given to our colleagues, is attached as an exhibit, not an exhibit, simply as an attachment to our submissions. And this is the evidence he would have given had he been required to testify orally before you. And then in para 34, we refer to the admission of the entire file and record. The nature of the agreement, members of the board, is quite important. And you will find this wording in Exhibit C, but we've referred to it again in paragraph 35. It says that the evidence leaders and the National Commissioner's legal representatives have agreed that the evidence led of the following commission stands as evidence in this inquiry unless pertinently contradicted by evidence led at this inquiry. So that was the qualification. It stood as evidence unless contradicted pertinently by evidence in this inquiry. We then say, and we're now dealing with a law, that a distinction has been made between the findings of the following commission and the evidence led thereat. In the President of the RSA versus SAFU, the Constitutional Court held that the Executive was not obliged to accept either the factual findings or the recommendations of a Commission of Inquiry, which the following Commission was. A Commission's report may be acted upon or not as the President and the Executive considers fit. And this was repeated in Minister of Police and others versus Premier of the Western Cape and others, which was a case dealing, as you would know, with the Reagan Commission in the Cape, where the court repeats in the middle of that paragraph 44, the President is not bound by the recommendations of the Commission and may implement only those he or she chooses. The court further held, and that's again with reference to SAFU, that a Commission of Inquiry is an adjunct to the policy formation responsibility of the President. It is a mechanism available to the President whereby he or she can obtain information and advice. Then on the next page, we continue to refer to that case and to one of the principal purposes of a Commission of Inquiry in Canada, and it's a quote from a judgment by Corey J. in the Canadian Supreme Court in Phillips v. Nova Scotia, where the judge says one of the primary functions of public inquiries is fact-finding. And this directly refers to the context of the following commission. They often convene in the wake of public shock, horror, disillusionment, or skepticism in order to uncover the truth. In terms of public questioning, stress, and concern, they provide the means for Canadians who read South Africans to be apprised of the conditions pertaining to a worrisome community problem and to be a part of the recommendations that are aimed at resolving the problem. Both the status and high public respect for the Commissioner and the open and public nature of the hearing help to restore public confidence not only in the institution or situation investigated, but also in the process of government as a whole. They are an excellent means of informing and educating concerned members of the public. And another Canadian case, also Corey J., and this is Canada Attorney General v. Canada Commission of Inquiry on the Blood System, referred to in paragraph 39 of our submissions. Corey J. characterized the findings of the Commission inquiry as follows. The findings made by a Commissioner, moreover, are merely statements of the Commissioner's opinion with respect to the conduct of a person. Such an opinion does not have the weight, force, or effect of a judgment. That accords with our law, as we understand it. In paragraph 24, Corey J. goes on to set out the basic principles which are applicable to commissions of inquiry in Canada, and we submit also here. And they are that a commission of inquiry is not a court of tribunal and has no authority to determine legal liability. A commission of inquiry does not necessarily follow the same laws of evidence or procedure that a court of tribunal would observe. It follows from 1 and 2 above that a commissioner should endeavour to avoid setting out conclusions that are couched in the specific language of criminal culpability or civil liability. Otherwise, the public perception may be that specific findings of criminal or civil liability have been made. The Commissioner has the power to make all relevant findings of fact necessary to explain or support the recommendations, even if these findings reflect adversely upon individuals. The Commissioner may make findings of misconduct based on the factual findings provided that they are necessary to fulfill the purpose of the inquiry as it is described in the terms of reference. The Commissioner may make a finding that there has been a failure to comply with a certain standard of conduct, so long as it is clear that the standard is not a legally binding one, such that the finding amounts to a conclusion of law pertaining to criminal or civil liability, and finally, a Commission must ensure that there is procedural fairness in the conduct of the inquiry. We submit all of those for an application in our system as well. And that is the reason, members of the Board, why the Parliament Commission did not find the Commissioner or anyone else guilty of anything. And that is why, an important reason why this Board of Inquiry has been set up, precisely because the Farnham Commission inquiry did not have, was not given the power to make findings of fact which would amount to civil or criminal liability. This board does have the power to make findings of fact we submit, which will have civil consequences if your recommendation is, as we submit it should be, that she's unfit for office, and if that recommendation is accepted by the President. Now, in paragraph 25, we say, in line with the above authority, the evidence leaders do not rely on the findings of the Farnham Commission, but instead on the evidence led thereat. And we've always been very clear in our submissions and our heads of that distinction. In paragraph 26, we say, in contradistinction here to the National Commission's submissions do not always distinguish between the findings of the Farnham Commission and the evidence led thereat. But this notwithstanding, it is clear on a fair reading of the submissions that the National Commission accepted that the evidence led at the Farnham Commission constituted a prima facie case against her. In this regard, the contents of paragraph 8 of the National Commission's statement of response is of particular significance. She states the following. 8.1, the Farnham Commission is a fact-finding mission. 2, could make no findings which are binding on any person or party. That's correct, in terms of what I've just read to you. Now, we've underlined what we say are the particularly relevant submissions for our purposes, and the next one is one of those. Its findings, insofar as they are adverse to a person or party, merely constitute prima facie evidence against that party or person. And therefore, 3, such adverse findings are in no way conclusive and definitive. We agree with that latter part. We also agree with the first part. Then 8.5, an inquiry of this nature provides the National Commission with an opportunity to, if needs be, 1, discredit the findings in order to demonstrate to this inquiry that there was no legal or factual basis for such findings, or 2, adduce evidence to this inquiry in person or through other persons, including documentary and otherwise, about her innocence. So that was clearly understood by the National Commissioner when she filed a statement of response. That is the purpose of this inquiry. She can discredit the findings in order to demonstrate there's no factual basis. She can also adduce evidence by herself or other witnesses as to her innocence. 6, demonstrate to this inquiry that the said adverse findings are not supported by the evidence that was led during the Farnham Commission, or that the evidence that was available to the Farnham Commission points to the opposite direction of the conclusions reached by the Farnham Commission. The upshot of this is that this inquiry, which sits as a disciplinary inquiry or akin to a disciplinary inquiry, is not bound by the adverse findings made by the Farnham Commission, which was correct. 8, and this is the crucial thing, members of the Board, which we've underlined, but it is entitled to accept as a point of departure that those adverse findings constitute prima facie evidence against the National Commissioner. So that was clearly understood by her, that the relevant factual findings by the Farnham Commission constituted prima facie evidence against her, not against anyone else, against her. And then 8.9, which still required to be proven by the employer for purposes of this inquiry on the balance of probabilities. Now, if I can just stop there, Judge, members of the Board, and deal with that last point, because that appears to be a reference to the well-known trite principle, which I'm not going to bore you with, we all know it, that the onus never changes in a matter. And the onus is fixed by the law and the pleadings. And once the onus is fixed, it doesn't ever change. But what does change and move during a matter is the burden of persuasion and the burden to adduce evidence. And if a case is made out against you, just to summarize, if a prima facie case is made against you, and you elect not to rebut that with evidence, you run the risk, which very often is the inevitability, that notwithstanding where the onus lies, that is going to come back to haunt you if you don't lead evidence which you could have led when there's a prima facie case against you. Now here it's admitted by the National Commissioner in a response that there's a prima facie case against her. And yet she didn't testify. And that point we make in paragraph 27. Then in paragraph 28, we deal with Geland v. Dixon, where the court deals with the failure on the part of one of the parties to give evidence on matters that were unquestionably within his knowledge. This is a civil case, as appears from the heading, or from the name. I'm not going to read all of it to you, but if I could ask you to go to page 36, and to the parts on 36 and 37 that we've underlined, which is the most relevant for our purposes. In the case of the party himself, who is available, as was the defendant here, it seems, sorry, perhaps I should, I can't just begin reading there.
Well, we've read it.
You've read it. It's relevant to the issue of someone who doesn't testify. It seems to me the inference is at least obvious and strong that the party and his legal advisors are satisfied that although he was obviously able to give very material evidence as to the cause of the accident, he could not benefit and might well, because of the facts known to himself, damage his case by giving evidence and subjecting himself to cross-examination. And then after saying it's not advisable to lay down any general rule as to the effect that may properly be given to the failure of a party to give evidence on matters that are unquestionably within his knowledge, the court says, but it seems fair at all events to say that in an accident case where the defendant was himself the driver of the vehicle, the driving of which the plaintiff alleges was negligent caused the accident, the court is entitled, in the absence of evidence from the defendant, to select out of two alternative explanations of the cause of the accident, which are more or less equally open on the evidence, that one which favours the plaintiff as opposed to the defendant. And that is known as the Gallant rule. Which
that has not been amended by the Constitution. The criminal law inferences that are to be drawn from an accused not testifying have been changed by the Constitution.
That's correct, Judge.
But this is in a civil case, and we're dealing here with a civil case. The Constitution did not amend that.
In our submission it didn't, and we refer in paragraph 29 to the endorsement of the Gallant rule by the Supreme Court of Appeal in your Down v. Bloemfontein Transitional Local Authority and another.
Correct.
So, subject to any other argument, we say no, it didn't. Now, in Mahmoud v. Janssen van Rensburg and others, and the not so older, the more seasoned members present would know that that case is a criminal case, despite the name. That is, as far as I know, the only successful private prosecution in this country, and it was pursuant to the so-called Trojan Horse massacre in Cape Town in the 80s, where the families, when the prosecutors would not prosecute, the families prosecuted.
What is the citation of that case, Mr.?
I'm terribly sorry.
Versus Jan van Rensburg.
It is, we've given it right at the end, I think. Well, no, sorry, we haven't. I'm terribly sorry. We will give it to you.
Yes, thank you.
We will give it to you. I apologize for that. And there the court said, and that would be the court on the appeal court, because it was taken on appeal. But we'll give you the reference. In the present case, an adverse inference of guilt must be drawn from the failure of the respondents to testify. And sorry, can I just, it now comes back to me. The initial prosecution was unsuccessful in the Cape. It was taken on appeal, and the appeal succeeded. The appeal court said that overturned the acquittal and brought in a finding of guilt. In the present case, an adverse inference of guilt must be drawn from the failure of the respondents to testify. While the court stated that it gave weight to the failure to testify, it did not make it clear precisely what inference was drawn. On the facts found by the court, and given the strong findings of probabilities in favour of the prosecution, the failure by the respondents to testify should, in law, and on the application of the correct legal principles, have been a decisive factor in determining the guilt of the respondents. And then there's some,
I'm not sure that this case is relevant to us, Mr. Jamie. This is a criminal case.
It's a criminal case, Judge. We submit not in the context of criminal liability, clearly, but we submit the principle carries over to the civil position where the failure to answer a case where there's direct evidence against you, we submit,
There's been a series of cases
must be held against you.
from the Supreme Court of Appeal as to what inferences may or may not be drawn in criminal cases where an accused does not testify or does not put a version to the state witnesses. And that is a totally different kettle of fish to what we are dealing with here.
I don't persist with the point.
Yeah, I think so. Thank you.
And then we say that the above cases in paragraph 31, Judge, and members of the board, are to be contrasted with that of SA Veterinary Council, the Veterinary Defence Association, which Judge Farlam, as it was, relied on the Gallant rule, but nonetheless found that a prima facie case had not been made out against the doctor concerned. And the passage there, the court said, I say this because in my view the tribunal did not consider whether there was a prima facie case, which became conclusive when it was not answered. It is plain from the tribunal's reliance on the second appellant's interpretation of the decision in Procureur's order van Transvaal v. Kleinhans, and its statement that Dr. Kravitz's failure to cooperate and assist left with no option but to find him guilty, together with the statement in the supplementary reasons that it was not correct to speak of a prima facie case not having been established against Dr. Kravitz, that it approached the matter on a totally erroneous basis, and as Rue J. correctly found, that it found Dr. Kravitz guilty simply because he failed to testify without considering whether a prima facie case had been made out.
Again, this turned on its particular facts.
It does turn on its particular facts.
And I don't think we can extend the principle of law to be applied to this case from this particular.
The only point we make, Judge, is that in this case there's an acceptance of a prima facie case having been made out against the National Commissioner in the Farlam Commission.
Yes.
So on an application of the law in this case to those facts, we submit the same conclusion should be reached. So that, but obviously it's specific to its facts. And we don't, and the same goes for the passages in Para 32.
Yeah.
Then in conclusion on this point, we refer to Stratford J.A.'s dictum in Ex parte Minister of Justice in re R.V. Jacobson and Levy. If the party on who lies the burden of proof goes as far as he reasonably can in producing evidence, and that evidence calls for an answer, then in such case he has produced prima facie proof, and in the absence of an answer from the other side, it becomes conclusive proof.
Yeah.
And that's the principle that we rely on.
That principle is well established.
Is well established. And then just as a gloss on that, in a criminal context again, but I think the principle is applicable here too. Block J says that prima facie evidence is more than merely some evidence. It is evidence of such a character that if unanswered, it would justify men of ordinary reason and fairness in affirming the question which the party on whom the onus lies is bound to maintain. As such, it amounts to evidence calling for an answer and which places an evidential burden on the opponent. And we submit, members of the board, that that is the applicable and correct approach. And then in paragraph 35, on this point we conclude that the evidence led at the Farlam Commission, augmented by the evidence led in this inquiry, both orally and in writing, constitute a prima facie case which the National Commission was called upon to answer. This was correctly acknowledged by her in a statement of response as referred to above. Accordingly, her failure to testify or to call any witnesses, we submit, is only consistent with the conclusion that she and her legal representatives did not believe that she would lead evidence, either personally or through witnesses, that would vindicate her. We submit that there is no other conclusion that can be drawn. Furthermore, it is submitted that she and her legal representatives concluded that she could not be subjected to cross-examination, as this would be destructive of her credibility. Now, Justices, in that regard, I want to refer to, now, you may not have it because we didn't think we would need it, but it's some material which is relevant to this question of the not calling of the National Commission. I want to put this before you. As it happens, it's been put before you as a bundle which was marked Exhibit A. You'll recall that when I commenced with my submissions on day one, our colleagues provided a bundle of correspondence to you.
Yes.
Do you happen to have that by any chance?
Yes.
You do.
Here it is. Which page you want to refer to?
I want to refer to my letter to Mr. Mortuary, which is at page 13, but I want to refer to paragraph 8 at page 15.
Page 13.
It begins at 1.3, Judge, but I'm referring to page 1.5, 15.
All right, let's just make a note here.
Yes.
Page 1.5, yes.
Sorry, my junior advocate Kuzovitsky has given me the reference to the Mahmoud v. van Rensburg case. Can I give it to you?
Oh, yes, thank you. Let's just write that in. Where do you refer to that again? Page?
It is 1993.
Say that again?
1993,
Yeah.
1, 777. SA 777, A, and the passage we quote is at 791F to 792C.
719F.
791F, Judge, to 792C.
792C. Thank you very much.
Thank you, Judge. So, paragraph 8 at page 15 of this bundle,
Yes.
the following is said by the evidence leaders. The evidence leaders also envisage that apart from some witnesses who may be called in respect of specific aspects relating to the terms of reference, particularly witnesses who either were not called upon to give evidence to the Farnham Commission or whose evidence needs to be supplemented in that regard, the evidence leaders will not be leading evidence that has already been led at the Farnham Commission. The evidence leaders accordingly envisage that the principal witness who will be required to give evidence at this Board of Inquiry, at the Board of Inquiry, and to explain the conduct will be your client, the National Commissioner. So that was the position that was put to her, and then, or put to them, sorry, and then in paragraph 10, sorry, in paragraph 9 we say we make this point now so that you and your team can take it under consideration as it will materially affect the manner in which the board proceeds with this task. We would appreciate an indication as soon as possible as to whether your client is in agreement with the proposed modus operandi proposed herein. Now, there was a response to that letter, but not in that regard. So then in a follow-up letter, Judge, which you find at page 19 from the State Attorney, and I want to take you to page 23 at paragraph 10 of the letter. The point is raised again. We further note that you have not in your aforesaid letter dealt with the content of paragraph 8 of our earlier letter, in which the view of the evidence leaders that your client would be the principal witness of the Board of Inquiry was set out. We ask that you do so in your reply, once again, in order to guide us in our approach to this matter. And we submit that was a sensible request because we needed to know how this matter was going to run and what the order of witnesses were going to be. Now, in response, Judge, and members of the board, at page 25 is a letter from the National Commission's attorney, and the relevant paragraph is paragraph 6 at page 27, where she says the following, and this is relevant. The reason I refer to this is the assessment at that point of the legal representatives as to the need to call their client. And they say the following: the issue of whether our client will be the main witness or not is, in our opinion, not determinant of anything. And then, it is without doubt that since the terms of reference largely relate to her, it would be prudent that she testifies. However, this does not limit her to being the only witness that will be called by us. So the clear understanding that we were placed under was that she would testify, and she would be, and we'd be allowed to take her under cross-examination and clarify the issues before this board. And any argument that you may hear that an assessment was then made that she need not testify, well, you'll examine that in light of the evidence that there is against her. But all we say is that that certainly wasn't the position on the date of that letter. Judge, we now turn to the actual details of the various terms of reference, and this is largely a repeat of what we've said in the statement of case. And I don't know to what extent
Can we just wait the stenographer? Do we need to take an adjournment again for the stenographer or not? she's been busy. Thank you, sorry. Just housekeeping. No, we can carry on, thank you.
Judge, I'm about to deal with the 5 terms of reference. This is largely a repeat of what we've said in the statement of case.
Oh, okay.
I don't know how you would prefer me to deal with this.
Well, you're free to deal with it as you see fit.
No, but I'm acutely aware of the need not to bore you and not
Yeah.
to flog a dead horse by reading things that everyone has read. So perhaps I'll go through it. I'm not going to refer to every paragraph and merely take you through it.
Yeah.
Our submission, members of the board, is that on this term of reference, namely whether the National Commissioner acting together with other leadership of the South African Police or alone misled the Commission by concealing that it had made the decision to implement a tactical option taken at the National Management Forum meeting on or about 15 August 2012. In paragraph 37, we say that on a proper conspectus of the evidence, it's been established that the National Commissioner, acting in concert with other members of the police, attempted to mislead the following Commission by concealing the fact that the decision to implement the so-called tactical option had already been taken the night before, at an extraordinary session after the formal NMF meeting of 15 August 2012. We say this emerges from the evidence, the exhibits, statements and concessions on the part of counsel for the police and from the National Commissioner's representations to the President in response to the Farnham Commission report.
That's actually your conclusion, isn't it?
Yes,
Yeah.
but we thought we'd put it up front, Judge.
Yeah, no, fine.
The point I just want to make about that, just to elaborate on it, is we use the words attempted to mislead, and those words are deliberately used because the attempt obviously was not successful. The truth came out.
Yeah.
Well, that will be disputed whether it's the truth, but what we say is the truth, and what our colleagues for Seri and the AMCU say is the truth. That came out. So the attempt was unsuccessful. But there's an argument in the heads, if I remember correctly, which I don't think we've dealt with in terms, but I want to make the point here, that there was no concealment because the evidence was led at the Farnham Commission eventually. But with great respect, if that is the submission that's being made, an attempt to mislead the Farnham Commission is as bad as misleading the Farnham Commission. So whether the attempt succeeded or not, the principal question is, was there proper disclosure which should have been made under the circumstances? And if the argument is, well, you don't have enough evidence to show that the Commission, the National Commission, deliberately tried to conceal these facts from the Farnham Commission, I'm dealing with that right up front. She should have got into the witness box and said so. She could have got into the witness box and said, I did what I did, I acted honestly as I saw that I should. I either acted on legal advice or it wasn't disclosed to me, other people may have done something, I didn't know about it, etc. That would have been what a forthright, honest person would have done under these circumstances. Would have taken the opportunity to clear a name, to get into the witness box and testify. This is a cloud that's hung over since 2012. And this was the opportunity for her to clear her name. So if there are, and we've referred to the legal provisions, the legal framework, if you are in two minds, Judge, and this is in the context of Galant, two minds as to what conclusions to draw, you would not be, with respect, as we understand the law, acting inappropriately to draw an adverse conclusion against the National Commissioner, given that she's not come to explain herself. So that's the context of the submissions we now make. So, to begin with, in paragraph 38, we refer to the opening statement of counsel for the police at the Farnham Commission, where he said the following. It's an excerpt from his opening address. Later that day, Mr. Matunjwa indicated to General Mpembe that at 9 in the morning the following day, i.e. Thursday, 16 August, the people will put down their weapons and that everyone will walk away, happy. By 9:30 on Thursday, 16 August, the people had not laid down the weapons. It was reported later that the protesters will not disarm. The Joint Operational Centre then took a decision at 13:30 to disperse the protesters, disarm them, and where necessary, effect arrests at 15:30. Now that is the statement by lead counsel for the police at the opening of the Marikana inquiry.
Who was the lead counsel?
Advocate Ishmael Semenya.
you.
Thank you, Judge. This is what he said. And there can be no doubt that this is what he believed on the basis of what he had been told. Now, if you just look at that opening statement, that passage from the opening statement, in the light of what we now know, Judge, and there's debate and there's an attempt to suggest, well, there wasn't a decision taken on the 15th of August, it was an endorsement of a decision, and then at one point there's no decision, then it was a decision, but it goes around in circles. And then we know from the SAB's heads of argument, which we've referred to in these submissions, that the National Commissioner's position is that both she and Commissioner Mbombo forgot to put the fact of the 15 August meeting in their statements to the Farnham Commission. And I'll take you to that passage. Both of them, not one, both, it was an oversight on both their parts to not refer to to not refer to the meeting of 15 August in their statements. And we know the National Commissioner made more than one statement, as did, I think, General Mbombo. So that's the first oversight. The second oversight, members of the board, is they overlooked the fact that there's no mention of that meeting in Exhibit L. Now, there's a suggestion in the argument that we read from our colleagues that Exhibit L isn't evidence. Well, I'm sorry, Exhibit L was the principal police document put up at the Farnham Commission. The police said, this is what we've spent a month or whatever it was doing at Roots. This is what we produced. This is the Magna Carta of what we did, and here it is. And we know, and we've referred to it in our heads, members of the board, that she was expressly, when she did give evidence, she was expressly asked about Exhibit L by Judge Farnham. We've given that extract in our heads of argument. If you read that extract, just reading it cold, it's hard to conclude with due respect that she was not being evasive in her response. Because he asks her, did you approve of it? And she says, well, endorsing is not the same as approving. And then he goes around and around and eventually says, can we at least agree that you did not disapprove it? And she says, yes, I did not disapprove it. That's not the way...
Well, a double negative is a positive, isn't it?
Yes, but when asked pertinently...
I was taught that in mathematics at school.
Absolutely, Judge. The point being that when asked the first question, did you approve this? And this happened, remember, the Roots conference was, or the Roots workshop, was established quite soon after Marikana. It was an attempt, in fact, the evidence is on record. It was an attempt by the police, well, the evidence leaders, I think, suggested it was an attempt to cover up. And I'm not going to go that far, I don't need to go that far. But it was certainly the police's preparation, we know, for Marikana, for the Farnham Commission.
Yes.
Now how?
Just tell me, where does the word roots come from? Why roots?
Because, as I understand it, Judge, it was a particular place, the Roots Conference Center. It's Roots, maybe it's Roots, not Roots.
Roots.
Sorry? It's in Potchefstroom, Judge, so I can't speak of
Oh,
Potchefstroom.
is it the name of a building?
I don't know what it is, Judge.
Mr. Mpofu, tell us, is it the name of a building or what?
Thank you, Judge. Yes, our understanding was that it was a conference center which was merely hired by the police to hold the
Was the conference center's name
Roots, yes.
R-O-O-T-S.
RWOTS, and they held a 9-day conference there to prepare.
Oh, it's not that the police went back to their roots to find out what happened.
It would have been better if they did.
Thank you. Right.
It could be Roots, Judge, Roots, the name. But
Yeah.
so the position of the National Commissioner, Judge, is not only did she and General Mbombo, it was an oversight that they don't mention this meeting in their own statements. It's also an oversight that it's not mentioned in Exhibit L. When she's expressly asked about Exhibit L, when she gives evidence, and she eventually says, yes, I didn't disapprove it.
Yeah.
And then, we've said it all out in great detail in our heads, and I'm going to refer to some of it. But we submit that the entire version that you were given, or that she gave at the Farnham Commission, is simply not plausible and not believable. And the fact that she has evaded answering those questions, very pertinent questions. This is a specific, the first and most, possibly the most important term of reference for this inquiry. Was there a deliberate cover-up by the police? And in the light of all this evidence, she elects not to come and testify. Now, you'll know as well as I, Judge, that in arriving at an assessment, and this has been said in the context of recent cases, evidence is a mosaic. You look at all the different pieces, you put them together, and at the end of the day, something emerges, and you then, as the finder of fact, you arrive at a conclusion. It's not a gut feel. You're supposed to avoid the gut instinct, the immediate instinct. You assess everything, everything fits together, and I don't need to tell you that. So there are so many pieces of evidence, little bits and some not so little, that point to one conclusion that we submit. Two things. The one is that on the balance of probabilities, that conclusion is the one you should reach. But even, I don't need to go that far, because all I need to say is that this case that we make out in this section undeniably presents a prima facie case that called for an answer from the National Commissioner. And in choosing not to answer what we say here, that's a damning acceptance of her that she could not provide an answer. Now, if we go through them, we begin at paragraph 40. In fact, sorry, before paragraph 39 is very important. We say, and we're giving you the footnote in footnote 30, we say that the police members who testified at the Farnham Commission consistently gave a version that mirrored what Advocate Semenya had said in the opening address, namely that the decision to move to phase 3 of the plan and to disarm the strikers was only taken on 16 August at the 1330 Jocham, which is Joint Operation Command
Committee.
Committee.
Joint Operation
Command Committee. And had been prompted by an escalation of the risk of violence breaking out if the strikers were not disarmed. So in other words, Judge, the case that the evidence that was led at the Farnham Commission was that evidence, initially, was that things had deteriorated. Mr. Matunja couldn't deliver on his 9 o'clock disarmament, and then the police make an assessment as the day goes on, and by 13:30 they say, hang on, we've now got to call, we've got to move him now, and we can't allow this to continue. Now, that account, of course, if there was a decision the previous night, which conveniently we have no record of, because the record has been either destroyed or disappeared, so we don't have a record of it. It's never disclosed. With all these opportunities to disclose it, no one discloses it. It then comes out, and she's recalled to give evidence. And then she tries to suggest that she had referred to it. And I'll take you to those passages. We submit that the only conclusion, or the point rather, is this. If the decision is, as the Farnham Commission eventually finds, that the fateful decision to resort to the tactical option on 16 August was made on the evening of 15 August, and the only trigger was that they don't disarm at 9 o'clock in the morning. The moment they did not disarm at 9 o'clock, their fate was effectively sealed. They were going to be disarmed with force by the police. And that decision was not motivated by tactical, operational considerations on the 16th. It was motivated, and the decision was taken on the 15th. And that's the crucial point. That's why this term of reference is there. So, if you consider, Judge, and members of the board, that is the two versions, sort of as it were, then it's highly relevant to understand what the evidence was that the police led at the earlier stage of the Marikana inquiry. And it may just be apposite to take you to a particularly clear indication of what it was that the police were saying at the beginning. Maybe it's not a good idea to go out of step, Judge, because I can't find the passage, so I'll come to it, if you don't mind. I'll just continue with the written argument. So if we go then to paragraph 40, we say, in addition to this, a number of items of real, in other words, documentary or video evidence, was presented at the Commission, which set out the above version. And with hindsight, these could only have been manufactured for such purpose. And I'm not suggesting here that the Commissioner had first-hand knowledge of manufacturing, but this is the objective position. These could not have been correct items of evidence. So we have a minute, in 40.1, we refer to a minute of the 6 o'clock Jocham meeting prepared at the Roots Conference and disclosed to the Commission by the police as Exhibit TT4. That makes no mention of the announcement at that meeting that 16 August was D-Day, and instead suggested that Phase 3 of the plan would be implemented only if the situation escalated. Now, that could never have been the situation if, in fact, a decision was taken the previous night. Then, 40.2, we refer to Brigadier Mkwanazi's evidence, or sorry, during his evidence.
Just a minute. This minute
Yes, Judge.
was a minute of a meeting at 6 o'clock of a JOCOM meeting on what date? On the 16th?
16th of August, 2012. That meeting is referred to in various documents and passages.
No, I just wanted to make
Yes.
sure.
Then, Judge, during Brigadier Mkwanazi's evidence, counsel for the police presented a revised version of Exhibit SS3 as being an accurate account of the plan that had been at the disposal of the police prior to the commencement of Phase 3. It stated the following: Lieutenant General Mbomba has evaluated the situation and instructed Major General Annandale to proceed with the implementation of Stage 3 of the operational strategy.
What's the time frame of that?
This would be the 1330 Jocham meeting, which is referred to. And I'm going to take you to, in fact, Judge, could I? If I can take you, members of the board, to volume 1 of our index, the 2-volume index,
Yeah.
and to item, sorry, it's footnote number 15, so it's on the second page of the index, and you'll see there's Exhibit SS3, page 85, well, SS3. And SS3, so we've just given you the relevant page. We haven't given you the entire document, but you'll find the page, Judge, and members of the board, at paragraph 39. So it's paragraph 39 of this document.
Page 39.
The pages are numbered in the top right-hand corner.
Yeah, 39.
Do you have page 39? It's headed Operation Platinum.
Operation Platinum.
Yes.
Lonman Mine, Marikana,
That's
16th August, Stage 3.
That's correct. So there you find what we quote in para 40.2, the first part, and this is 1330. Now, in para 40.3 of our submissions, we say the document goes on to list a series of supposed indications that the threat level was increasing, thereby necessitating action. This was in fact not a true reflection of events on the day, and the so-called plan was a result of reverse engineering that was presented as a true reconstruction of the actual plan. So what this minute purports to do, members of the board, is to indicate to you a running sort of commentary and record of what happened. And that's why you see it says current information on page 39. And after saying Lieutenant General Mbomba has evaluated the situation, instructed Major General Annandale to proceed, it says the threat level is increasing. So now it's purporting to give objective events at the time which now motivate the police to go over to disarming the strikers. Media reported to Captain Adriah the crowds have identified the SABC video operators and are threatening to kill them. Reports from the negotiations in Yala are that they've received threats from the protester representatives. Reports from the police on the front line are that the group is still militant. the media have picked up that there's a restlessness among the protesters and have been shown a firearm wrapped in a blanket. And then the deadline to lay down arms this morning has not been honoured. But, Judge, if it was a done deal that the operation to disarm was going to happen that day, and we submit the overwhelming evidence is that it was, then that can't be correct. It can't be true that motivated the police to act at the time. It's only consistent with the fabricated, made-up version, which is what the Farnham Commission found was, in fact, the case.
Where did you find that this Operation Platinum purports to be
A minute.
a minute of the time 13:30 on 16th of August?
If I can give you, Judge, yes, what we were trying to do with this aid memoir is just to give you the relevant page, and not the entire document. As you can see, it's page 85. So, but if I can assist you in this regard. I've made a separate copy, Judge, of Exhibit L, which is the principal police document.
Oh, yes,
And that is now, we haven't given you, Judge, we haven't prepared for you a separate document as Exhibit L, but we can certainly do so, and it helps. Well, all the exhibits are, as you know, Judge, you've been given a set with all the exhibits. So Exhibit L would be among those, but what we found quite helpful is that we copied it in color, and I don't think I have a feeling that the orange files are not in color, and thus it would be less usable. So what we will do is to provide the members of the board with, as we have it here, Exhibit L as a separate document in color. Because this, as we say, was the product of the Roots Conference. And this purports to give a chronological rundown, Judge, of the entire, not only the 16th, but the whole time at Marikana, from the 10th or the 11th. And to answer your question, and I don't know whether it's going to be placed in dispute, but the timeline of 1330, and can I just read to you what it says? And I think we have referred to it. Perhaps we haven't. Can I just read to you, Judge, what Exhibit L says at page 174, and perhaps you can just make a note, and we will give you this document.
Of this?
Is that Exhibit L?
No, it's not.
Sorry.
Oh, we don't have it, all right.
I'm sorry. I'm happy to hand this up, well, except I've made marks, so I don't want to hand this up to you.
Well, you can hand it up later.
We'll give you clean copies of Exhibit L.
Okay, thank you.
Exhibit L, Judge, which is, as I say, the product of the Roots Conference. It's headed on the title page, Mine Unrest at London, Marikana, History and Build-Up. And then it's got an introduction, and it runs to 284 pages. And it's a detailed presentation with photographs and video clips, I think, as well. But on page 174, under the heading A Detailed Sequence of Events, it has the timeline 1330. And then it says the following. The chairperson, Major General Annandale, called a special JOCA meeting to evaluate the current Now just focus on these words, if you will, Judge. Called a special JOCA meeting to evaluate the current strategy and the possible implementation of Stage 3. And then the Provincial Commissioner, Lieutenant General Mbombo, informed the JOCM that she'd been involved in a meeting the whole morning with the President of AMCU, Mr. Joseph Mtunjwa, to resolve the current situation. Mr. Mtunjwa was supposed to indicate at 9 o'clock whether or not the protesters on the copy were prepared to put their weapons down. Mr. Mtunjwa failed to provide. Just keep it up. Mr. Mtunjwa failed to provide feedback, as he agreed to do. And then you've got, not quite verbatim, but very similar reference to the one I've just read to you and which you're asking me about, Judge. And what you're asking me is about SS3. and the timeline. And what you find at the bottom of page 174 is the following. Under the same timeline, 1330, after evaluating the situation and from reports on the ground, the Provincial Commissioner instructed Major General Annandale to proceed with the implementation of stage 3 of the operational plan, dispersion into smaller groups, encirclement and disarming. So it's quite clear, and we've never understood it any other way. That was at the 1330 meeting. Can I just speak to my junior for a moment, please?
Mr. Jamie, I think we have to adjourn here.
Certainly.
For the sake of the stenographer, shall we adjourn for 5 or 10 minutes?
Certainly, Judge.
Adjourn. Just put your microphone on, please.
Resources there? It's volume 1. I have referred you to SS3, Judge. The supposed indications, and that we've dealt with. That was in volume 1. But just to, with regard to what you were asking me about the timeline, sorry.
Yes.
On the timeline on the minute which we referred to in para 40.2, that entire minute, Judge, is an exhibit, was an exhibit at the following commission, but it's also to be found at page 370 of volume 2 of the footnotes.
370 of volume 2. Just a minute. .370 purports to be exhibit EE.
That's correct. And you will see it's a special JOCA meeting, 16 August 2012 at 13:30.
Oh, I see.
And then you'll see on the purpose of the meeting, and there. So it's common cause from a number of different sources. The second paragraph under para 3, the Provincial Commission instructed Major General Annandale to proceed with the implementation of stage 3 of the operational plan.
Yes.
Thank you, Judge.
All right.
Then, Judge, if I could then move on to page 46. We make the averment in paragraph 40.4 that the 2 October 2012 draft of Exhibit L included a television clip of the Provincial Commissioner's 9:30 press conference on 16 August in which he said the following to the media: "What I told you is today we are ending this matter." And that clip was replaced, and we give you the references, and all of this comes from the evidence of the following commission, with a different clip from which the aforesaid words were missing.
Sure.
Now, Judge, can you try to find for me?
Is it known who tampered with this particular clip?
No one fessed up, Judge, but the reference to what I told you today, we're ending the matter, is missing from the second clip, which is to be found. Sorry. There's one passage from the evidence of Annandale quoted. I think yeah. Somewhere toward the end. Just see if we can find it. Then in para 41, Judge, we refer to the fact that while Lieutenant Colonel Scott was giving evidence, and counsel for the evidence leaders, I think it was Advocate Chaskelson, was dealing with whether or not there'd been threats and what the nature of the threats were on the morning of 16 August, which might have led to the decision to proceed with a tactical option. While he was doing that, counsel for the police intervened and said the following: "Chair, I'm aware that the evidence of General Mpembe, amongst others, is that there was an escalation intention leading up to the phase or stage 3, but as far as SABC's case is concerned, there was going to be stage 3 if the arms were not voluntarily surrendered by 9 o'clock as promised. That's our case. That there is evidence different is a different point." Now that was a diametrical volte-face, Judge, on the position, and I'm not sure that it was the same counsel who said that as Advocate Semenyo, who made the opening statement, but the two are entirely contradictory. So now the SABS case had become that if there wasn't a laying down of arms at 9 o'clock, then we're going in. But
which implies, if I understand your argument correctly, that prior to 9 o'clock, there must have been a decision to go ahead if the arms are not...
we know that there
laid
was,
down.
yes, and we know that there was such a decision, Judge, because we now know belatedly of the meeting of 15 August, at which the National Commissioner not only was present but presided. And this is all in the context of me demonstrating to you how the entire tapestry of evidence points all in one direction, Judge. And it points to a decision and then an attempt to conceal that decision. I've already referred to the fact that conveniently we have no record of that meeting. Conveniently, the National Commission and Provincial Commission, and it's not in our heads, I'll take you to where we give you chapter and verse. Their submission, or the SABC's submission in their heads of argument, was that both those, the most senior officers present, forgot. It was an oversight to not mention it in their statements. Now, how can that ever be, Judge? And if it was a genuine oversight, the least you should have done is come explain it to this Board of Inquiry as to how you could possibly have overlooked mentioning the most crucial meeting of the entire. So everything else, we have in this Exhibit L, 100 and however many pages it was, 200 pages document, prepared over 9 days at Ritz, and it's got all the other things in it. But the one crucial thing is missing, and it's not mentioned at all.
That's Exhibit L you refer
Yes,
to.
Exhibit L. I believe the IT people do have Exhibit L, and it may be shown, but I'm not sure that we need to look at it at this point, Judge. It's got some gory photographs in it, which I don't.
Well, are we going to see it or not?
Judge, sorry, Judge.
Yes.
Exhibit L is a document which my learned friend ought to have made it available in color to members of the board. So now that during argument there is an invitation to watch a video, then we are against that, because it is a document which contains pictures in color. So they just have to make sure that they get that document and make sure that as members of the board, each one of you has that document.
I don't know whether that's an objection, Judge. It didn't sound like
It is an objection.
To what?
Then to saying that we can then now watch the video, as I understood you. So as I understood you, you said that you will make a copy in color for the members of the board. So that you can do, we have no problem with it.
Judge, how I present my case and my argument is for me to decide and for you to rule on, if you think I'm doing something I shouldn't do. I've undertaken, I will give it to you in color in order to assist the board, because it's more relevant, or it's more readable in color.
I'm not objecting to that. That's what I'm saying, that's what you ought to have been doing.
I don't follow this argument.
I don't follow it either, Judge. Perhaps I should move on. We needn't waste time.
I'm not sure that...
Can I just make clear, Exhibit L is not a
I
video.
think it's fine. So let's leave it, and then so you can continue with this argument.
No, I'm sorry, Mr. Makari, but I don't understand what the objection is. If it's just a document, then there's nothing to watch.
Yes,
It's
then
a
if it's,
document.
yes, indeed. I mean, I understood him to be talking of something to watch. So that's why I'm saying that if he's talking about the document, there is no problem. That's what I'm saying.
Well, then,
Sorry, both Mr. Makara and I weren't at the Farnham Commission, so we had a disadvantage. Mr. Mpofu was, and he explains, and I discern this from looking at the printed version of Exhibit L. Exhibit L is a slideshow and was presented as such at the Farnham Commission. It's a succession of slides, Judge.
oh, I see.
But it pivots, but there are very gruesome photos as part of it, which I wouldn't want to show. And I don't think it'll serve any purpose for our purposes. So I don't want to put it up at the moment. We'll just... So I inquired about the possibility earlier, and I've just told now it's available. So I don't need to go there. If I do need to go there, I will decide that, because I don't think I'm going to finish today, and then I'll inform you in the morning, Judge.
Fine.
But for the moment, we don't need to go there.
But you are going to give us a copy of Exhibit L.
I may not be able to do so by tomorrow morning, unless we can get to, but we'll try.
Yeah.
We'll try to give you a clean copy in colour of Exhibit
Thank
L. Judge, sorry, it's relevant to this point. It's also relevant later on where we refer to it. But can I just, at this point, when dealing with the two versions, and can I just refer you out of sequence, as it were, to page 77 of our written submissions, where we deal with Major General Annandale's evidence. And this is among the extracts that is referred to in footnote 30 of our submissions. And this is what General Annandale said before the discovery judge of the meeting of 15 August. So this was the police version. And remember, Major General Annandale was the commander at Marikana. This is what his evidence was. Chairperson, prior to that meeting at 13:30, Major General Mpembe briefed the Provincial Commissioner General Mbomba. I was partially present during that briefing, but he and she was also there from time to time, so she was aware of a number of the happenings. It was not as if she's now receiving the first information of what has transpired on that day, but he indicated that feedback that we received from the operational commander. He indicated the change in behavior of the people. He indicated the threats that's been made by the leadership of the protesters to the police, and he indicated that there's a real risk associated if we would not take action to disperse the people. The risk was discussed without much detail, but it basically boiled down to the fact that if this disgruntled group of people, that we all had the impression that they would lay down their arms and that they would disperse peacefully, that didn't happen, and seems like even the president of AMCU, that he cannot control the members, he cannot convince them to actually lay down, and that the real risk is here that these people would go back from the Kopi, all of them in that group, armed as they were, that they would move into the neighborhoods and the villages, and then we will have, again, incidents of serious intimidation, of assaults and murders and damage to property. Chairperson, we're only too mindful what has happened in Implats early in the year, where there were several cases reported in terms of exactly the risk that we feared. My only experience in that regard is that it's extremely difficult to control any such groupings once they break up into literally tens of smaller groupings and people go into the neighborhoods, and then you cannot control individual actions. In Sasolburg in Zamdela is a recent specific reference to what I'm referring to, because that started with a small group of about 100 people. They were joined with a number more, and then the people took to the streets. Chairperson, in that process, there were more than 32 shops that were looted and about 180 foreign shops. But we've experienced that in my years, that you will get, the moment you break up such a group, and those groups go back, then they will loot and they will intimidate and they will attack, and people can get killed. The provincial commissioner, in terms of that briefing, then said we should go over on a stage 3 deployment. And based on that, I called a special JOCA meeting, because even although stage 3 was always part of the plan from the Tuesday, during the morning JOCA meeting, we did not go into the detail of that planning because we were still confident that there will be a laydown of arms. So that is the official police version, Judge, that was given, and that was consistently given till the discovery of the meeting of the 15th of August. And that version was a lie, and the commissioner must have known that that version was being given in public as the official police version. And she either knew that and went along with it, knowing of the meeting of 15 August, in which event she's clearly duplicitous and should not be National Commissioner, or she did not know about it. She did not know about what was being said on her behalf by her officers at the Farnham Commission, in which event she was grossly incompetent, neglectful of her duties, and also should not be National Commissioner. So on either of those alternatives, the position adopted by the police as evidence in all these pieces of evidence, the opening statement, this evidence of Major General Annandale, similar evidence by other police, Mpembe and so forth, indicates, is part of our argument that there was a cover-up. We then go to paragraph 42 of our heads on page 47, Judge, and the minute then is disclosed, eventually it comes out. And there's a minute of the extraordinary meeting that occurred after the formal NMF meeting. And that minute reads as follows. The National Commissioners opened the meeting and requested the Provincial Commissioner in the Northwest, Lieutenant General Mbombo, to brief the attendees on issues of the labour unrest in Lonmin Mine in Marikana Northwest. After deliberations, the meeting endorsed the proposal to disarm the protesting masses and further indicated that additional resources must be made available upon need identification by Provincial Com Northwest. Now, to just stop there and look at this minute, which is the first and only documentary evidence we have of what transpired at that meeting, Judge. This is the only document. This is the sole memorial of that meeting. And what this indicates is that...
That's the extraordinary meeting.
The extraordinary meeting. There's a minute of the ordinary meeting, but this happened afterwards. This is the sole memorial of the extraordinary meeting, and this indicates unequivocally that it was understood at that meeting, the National Commission and legal representatives don't like the word decision, but it was understood at that meeting, and it was so endorsed, that the following day the protesters were going to be disarmed. Oh, the footnote is J 177 at the Farnham Commission, Judge, and it is in volume 1 of our footnote bundle at page 139. You don't, I think, need to go there because we've got the whole text of it in this quote. And if you just read what it says, it's clear that nothing that was going to happen the next day, except the protesters not laying down their arms at 9 o'clock, was going to affect this decision. The National Management Forum, or the National Management, is the top leadership of the police. And they decided that the next day it was going to end. And appropriately, Judge, that command, that instruction filtered down the ranks. Because lower officers, lower rank officers, such as Captain Ntlati, sorry, not Captain Ntlati, but Captain Adrian and Advocate Captain Mormon, you and the media who were at Marikana on that day, they all used the term that morning, today's D-Day. That's what they all understood. Now, where does that come from? It's a very singular, unusual phrase to use. We all know what D-Day means. It's a reference to the Second World War, decisive day. Today is the day. The National Commissioner suggested she didn't know what D-Day meant. But D-Day, Judge, it's common parlance. You know what, we know what D-Day means. And why would all these people be using that phrase on that day if they've not been told today's the day? In fact, we know from the clips. The Provincial Commissioner's clip, as I've referred to, said, this thing ends today. And later on that clip is removed from the official version.
What should we infer from that? Just tampering of evidence or still an attempt to hide something? If so, what were they attempting to hide?
It would appear, Judge, that
it
would appear that it's a reasonable inference to draw from the facts that what they were attempting to hide was any documented indication that there was such a decision. And the removal of the clip from the official version would tie in with that narrative. I can't tell you who did it, I can't tell you who instructed it, but it all goes into the mosaic of the evidence that indicates, and as the Farnham Commission found, the police at the highest level were complicit in this concealment. Now, and just the point to just end off on paragraph 42 and that quote, it's entirely inconsistent with any operational decision being taken the next day based on what was happening on the ground. Because if your top commanders have already decided the night before that tomorrow's D-Day, then obviously you can't suggest the next day at 1 o'clock you're still taking a decision as to whether to do it. You've been told today is the day. So hence you must get on with it and do what you need to do. And that is the correct context we submit of what happened at Marikana. In paragraph 43 we say when the National Commissioner testified, and we give you the reference, she said that this paragraph had been added by her personally because the Secretariat had removed it from the main minutes of the NMF meeting. And what we say about that is that given that she thought the extraordinary session important enough, specifically to add a recordal of what had transpired there after this was initially left out, given that, her subsequent suggestion that she omitted through oversight to mention the meeting as part of the run-up to the following day's events at Marikana is far-fetched and unbelievable. And then we refer, and I've referred you to it already, Exhibit L asserts expressly and deliberately that the decision to disarm the strikers was only taken at 13:30 after an evaluation by General Mbombo of the situation on the ground. And I've given you that reference already, so I'm not going to refer to it again. Now, the next document that I want to refer to, members of the board, is Captain Wilman's written notes, which are J 168 at the following commission, and which we've handed out. And you'll recall Exhibit C admitted not only her evidence, her affidavits, but her notes, these very notes. And we've underlined the relevant, so the notes would be in bundle B. It might be elsewhere as well, but and remember, Judge, she was not meant to be taking notes. She was just hauled in and told, okay, you're going to take the notes, because the note taker, I think it was Brigadier Pretorius, was not there. So she then reluctantly took the notes. But this is the notes that she takes.
Is Captain Wilman a lady?
Captain Wilman is a lady and an advocate. She's in legal, Judge. So she, and the notes are, again, I don't need to take you there, but when you look at those notes, you will see that the very first thing of significance is the words D-Day. She's written there on top, D-Day.
No, where's that?
Sorry, maybe I should take you to a judge. Can I ask you to look at bundle B, Exhibit B rather? And the notes are at page 55 of Exhibit B. J 168 is
56, page 56.
Is page 55, but then you go to page 56. The notes begin: security deployment, radio technical held, mechanics not here to follow up, and then D-Day.
Yeah.
So it's at the beginning of the main body, and then it says the following. Terms and conditions. I'm now reading from the written submissions where we've typed out this. So her notes read as follows. Terms and conditions not to continue. Constitutional rights but boundaries. 10 killed, 2 SAPs. Firearms missing. Given we say opportunity to lay down weapons. Mine gave opportunity to work. Unions talked. Lay down and return. Denounced violence. And then we underline, will reaffirm today. Weapons to be left at copy. We say that should read copy, obviously. And then the next line, specific policing act, which I think should be action to take place, not limited to both hostels. Any person with weapon will be APPR, we say, apprehended and arrested. Negotiators will talk them through. We cannot entertain people with weapons. And then the next one is particularly significant. Remember, Judge and members of the board, this is at 6 o'clock in the morning. They must see it is stopping here and now. SAPs not retreating. Agreement, everything to be done on command. And then, chillingly, we submit in light of what happened afterwards. Today, things will be changed. So that was the posture of the police, Judge, members of the board. That was the understanding. And we ask, and we know that we've neglected to refer to it in our heads of argument, but Mr. Mpofo has, Advocate Mpofo has referred to it, and that is the evidence of telephonic exchanges, or rather telephone calls by Lieutenant General Mbombo immediately or shortly after the meeting on 15 August. She telephones Annandale and Pembe, a number of the commanders at Marikana, because obviously she's not at Marikana. And so we know that happened, that she phoned those people. And we also know, Judge, that at 6 o'clock the next morning, someone who has no reason to be making up anything, someone who's just thrown into the situation who's got to keep notes, Advocate Millman writes D-Day. And the only reason she would write D-Day is because someone at that meeting said today's D-Day. That's the logical inference, the only inference you can draw. So the police knew, Judge, at 6 o'clock that morning, right down the chain of command, that that date was going to end. And yet you have the deliberately untrue evidence of someone like Major General Annandale. His evidence simply can't be correct. It can't be true, given what we now know. And Brigadier Mkhwanazi and the other people whom we refer to in footnote 30, the evidence cannot be true. We then called, or we refer in para 47 to Captain Tlati's statement, in which he says, and you'll recall his evidence about the briefing in the veto at Marikana. He says, we were briefed by Lieutenant Colonel Scott and in the presence of Brigadier Pretorius. During the briefing, we were informed that the national management instructed that the police must act against the armed strikers as they had to be disarmed and dispersed. We supply that emphasis. We know that Colonel Scott denied making the statement attributed to him. Sorry, that's actually an overstatement. He didn't deny making the statement, if you look at that reference, which I'm not going to take you to, but I can assure you this is what it says. In his evidence, when this is put to him by Advocate Chaskelson, he says, obliquely denies it, because his answer is, I didn't even know about a national management for a meeting, and thus impliedly I couldn't have said national management. But he never says, I never said that in the presence of Captain Tlati. So what we say is an overstatement. But even accepting whatever, and you will go to look at the record, we say whether Captain Tlati heard it from, in fact, this entire submission shouldn't really be there, because it's now been overtaken by the evidence, because Captain Tlati, as you know, testified. We submit he was a very good witness. He was a straightforward witness. He answered questions in chief, as you'd expect from someone who was simply remembering what had happened. He was very strong, and then most tellingly, he wasn't cross-examined. So his evidence stands, and his evidence, Judge, members of the board, was that there's no doubt in his mind that this is what was said. He heard it. He was in the veto, you'll remember. And he said that a reference to police management includes the National Commissioner and Divisional commissioners. And then I asked him in a follow-up question, I said, would it include the police in Northwest? And he said, no, it doesn't include Northwest. National management, it was a rather silly question in the circumstances. National management is obviously national management, not provincial management. So he was very clear on that. National management, his evidence means the National Commissioner and Divisional Commissioners. Now, of course, he can't tell you anything about the National Management Forum meeting. You'll recall you asked him that in a question, Judge, did he say National Management Forum? And he said no, he said National Management. So Captain Tlati is not testifying that there was a meeting, whether something was said at the meeting. He's a low-level functionary. He knows nothing. He just knows that the briefing commander, Scott, said National Management has instructed that this has instructed the police to act. Now, it's a very important, it might be a small piece of the mosaic, but it's an important part of the mosaic. It calls out for an answer from the National Commission to say, she should have come and testified to say, I've got absolutely no idea why he's saying this. Or they could have called Scott if they wanted to. Simply not refuted. So you must accept that this was said, and then if it was said, which you must accept it was, why was it said? Why would Scott, the briefing officer, tell the other commanders, national management, which is parlance in the police for the National Commissioner, or at least includes the National Commissioner? In para 51, we refer to the fact that the issue of D-Day, the term was used by the media and by Captain Adriel. That's evidence is on record. We then refer to the mortuary vehicle evidence from all those officials who were responsible for mortuary vehicles. None of them had to be called because the Commission accepted the evidence. The evidence is very significant. Early in the morning, between 8 and 9, they were calling for a large number of mortuary vehicles. Now, it doesn't assist an argument to say, well, we just needed them there. Things have been going on from the 9th and 10th. People have been killed on the 13th. There's no record of any such interaction, and 4 vehicles is a large number of vehicles. I think it's on the record, on the following record, that each of those vehicles can take 4 cadavers, which means 16 people. If it's not on the record, then I withdraw the submission. But our information is that each of those vehicles can take 4 people. So the police, it's only consistent with the police as early as 8 o'clock on the morning of the 16th, expecting a large number of fatalities. Fatalities, not injuries, fatalities. It's damning inferential evidence that a decision had been taken by that time of the morning. The additional evidence, so we say the mere fact that the police as early as 8 o'clock are calling for 4 mortuary vehicles is damning. But then if you look at the additional evidence that goes with those requests, you see things like the occurrence book that we referred to in 52.3 of our heads. The mortuary vehicles were to be stationed at Marikana Police Station if any disaster that can occur during the strike. Now this is on day 4 or 5 of the strike. Any disaster that can occur.
There is a minute, it says requested only 1 backup mortuary vehicle to be stationed.
I'm sorry, Judge?
In your paragraph 52.3, you quote from the occurrence book, and it says on the last line on that page, requested 1 backup mortuary vehicle. Paragraph 52.2, you say 4 mortuary vehicles were.
Because the evidence of Colonel Claassen, Judge, that we referred to in 52.2, the initial request was for 4 vehicles. The Phokeng mortuary, it seems, could only supply 1.
Oh, is that
and
the-
we
was
only
that
have a
the
record.
initial request?
The initial request from the evidence by Colonel Claassen was that he received a message, this is we say in 52.2, he received a message from Colonel Mandoda asking him to arrange 4 mortuary vehicles to be placed on standby at Marikana. And then when it's fed through, they can only supply 1.
Your heads of argument doesn't say it was an initial request for 4 mortuary vehicles and then later changed to 1
No.
backup mortuary vehicle.
I don't think we didn't say it was changed, but as we understand the evidence and the documents, they could only supply 1. Sorry?
But the others did arrive after the first
Well,
one.
we know after the fact that they arrived because there were 34 bodies, but
Yeah.
I can't tell you what the position was, Judge, before Marikana, before the shooting.
All right.
And then, may I proceed, Judge?
Yes, please. Thank
In
you.
paragraph 52.5, there's the evidence of Mr. Tladanyane, and he says in the second paragraph, on my arrival at Marikana Police Station, I was escorted to Lonman Mine, there were lots of police, etc. And then the last sentence, Colonel Mandoda informed me that we are called there as role players, so that if there is death, then we can transport the deceased to the mortuary. It was around 9:50 that morning. I stayed there until the following day. This is again very significant, 9:50 in the morning, Judge. A mortuary vehicle is being put on standby so that if there's death, there can be, we submit no argument with the fact that the police knew they were going to act at that time already. And sorry, if I can just refer to the evidence in 52.6, it answers your question, Judge, I think, who I submit. The evidence by Josephine and Clarke to the following effect. On Thursday, 16 August 2012, in the morning, I was officially on duty at the district office when I received a call from Colonel Claassen of Phokeng SABC. Colonel Claassen informed me they are going to close down the miners at the Kopi in Marikana. So this is the morning. And he requested 4 mortuary vehicles to be sent to Marikana for standby. I indicated I can only send 1 vehicle. And I further requested Claassen to send me a letter of request. I then received an email from Riah Phiyega, SABC. 4 vehicles were requested by Colonel Claassen in the morning. And that, 1 vehicle might be one thing, Judge, but 4 vehicles. Significant fatalities were foreseen already in the morning.
Yeah, I see that, man.
And then, finally on this point, 52.7, at 10:53 that morning, an email was sent from Colonel Claassen, obviously in response to a request for an email to Ms. Nake, which said the following: the request is for a forensic vehicle to be sent to Marikana for standby, as there will be a cordon and search operation taking place today. This request comes from National Head Office. Now, Judge, depending on the extent to which you go into the evidence, we know from the evidence that Captain Moorman was involved in preparing the legal documents for a cordon and search operation, which would have taken place at the hostels. That has nothing to do, as we understand the evidence, with the action at Marikana on the ground. You needed some sort of legal document or an affidavit to get permission to cordon off and search an area. So that is what they were talking about. That's the reference to a cordon and search. That has nothing to do with the action against the miners at Marikana. We say then, Judge, in para 53, the evidence, all this evidence above indicates that a decision had already been taken by the morning, by 9 o'clock, to proceed. Against the strikers, para 54, we refer to the Farnham Commission finding that the leadership of the police, and this is the finding which triggers this first term of reference, so this is what the Farnham Commission found. The leadership of the police on the highest level appears to have taken the decision not to give the true version of how it came about that the tactical option was implemented on the afternoon of 16 August, and to conceal the fact that the plan to be implemented was hastily put together without POP inputs or evaluation. In order to give effect to this, the decision at the NMF was not disclosed to the Commission. An inaccurate set of minutes for the 6:30 meeting was prepared, and a number of SABC witnesses testified before the Commission in support of the incorrect version. There is at least a prima facie case that the National Commission and the Provincial Commissioner for the North West Province, who knew the true facts, approved Exhibit L, SABC's presentation, which contained the incorrect facts. In the circumstances, the Commission recommends that steps be taken in terms of Section 9 of the SABC Act to inquire into their fitness to remain in their posts and whether they are guilty of misconduct in attempting to mislead the Commission. We submit in this Board of Inquiry, members of the Board, that finding is entirely justified, and that in the absence, more especially in the absence of an answer from the National Commissioner, it becomes conclusive, those findings. We say in 55.2, there's sufficient evidence before the Board of Inquiry to find on the balance of probabilities that the National Commissioner knew the true facts and that she nonetheless approved Exhibit L, the SABC presentation which she knew contained incorrect facts. We elaborate on the submission hereunder. Judge, I see it's now 4 o'clock. There's no prospect of me finishing today. Would it be an appropriate time to take the adjournment?
Let's just tidy up a bit here before we adjourn.
It's taking long. It's taking long. You see the work?
And these documents stay here. I think we can stay here, can't we? Okay. Oh. This is not staying here. This is not staying here. Right, you ready? Thank you. You can adjourn.